Welcome to the class Constitutional Law video series. In this series, we were talking about writs. In the first video, we had a general introduction about what is writ, isn't it? If you have missed to watch that video, I'm providing the link in the description box. Please go and watch it. Okay, so in this video, we are going to talk about one of the most important writs issued by the Supreme Court and High Courts in India, that is Habeas Corpus. So let's see. Yes, the Great Writ. All over the world in democracies, habeas corpus is known as the Great Writ. So apart from other writs, it's very clear that there is some importance or significance attached to this particular writ, isn't it? Yes. Let's see what it is. The word habeas corpus, no, of course it is Latin. It means have the body of the person. Okay, so that gives a clear indication as to in which situation this particular writ jurisdiction is invoked. Yes, it is to protect individual freedom. That's the most important, most significant ingredient of democratic life. Yes, so whenever an individual freedom is detained illegally, that means a person is illegally detained by another person, normally by government or executive authorities. It is at this time that this particular writ is invoked. So you can approach Supreme Court under Article 32 according to Indian Constitution when a person's individual freedom is curtailed or the right to freedom is being violated by any other person. Normally, it is the police or any other executive authorities who are detaining individuals. So, by approaching Supreme Court, we can ask for three kinds of remedies in three different situations. The first situation could be that a person's freedom is being curtailed for no reason. That means the person has not done any offense, has not violated any law, and illegally the person is arrested. Okay, that is the first situation. So we are challenging the authority to arrest a person. Second one, the person has violated a law and that is why he is being arrested. But while arresting, the requirements of the procedural formalities are not followed. What all things are required to be followed while arresting a person, these procedural formalities are not followed and therefore the arrest becomes illegal even though the person who is arrested is deserved to be arrested. Okay, now comes the third situation. A person is being arrested. He has done an offense or he has violated a law. No problem. A person is arrested under a particular law by following all the procedural formalities. There is no problem at all. Okay, but the law with which he is being arrested itself is unconstitutional. Okay, so that also makes the arrest illegal. So in these three situations, the arrest by an executive authority becomes illegal and which can be challenged before the Supreme Court or the High Courts through a writ of habeas corpus. Okay, so a writ of habeas corpus is used to protect the individual freedom from illegal or arbitrary arrest by an executive authority. But is this only available against executive authorities or the public authorities? No, not at all. This is a peculiar remedy which is actually providing a procedural remedy to any petitioner. When I say the petitioner can be the person whose freedom is being curtailed, and sometimes the person whose freedom is curtailed is not in a position to approach the court. So anyone on behalf of him or her can also approach the court. Petitioner can be anyone, and against whom? Against any other person. Need not be an arbitrary executive authority. It can be even against a private individual. So one private individual detaining another private individual, then also we can approach the Supreme Court. Okay, so habeas corpus is such a writ which can even be issued against a private individual. Many of the writs cannot be done, but habeas corpus can be issued both against the government or public authorities and also against private individuals who are illegally detaining another individual. So this is very clear. By invoking habeas corpus, a person is supposed to be brought in front of the court. The person whose freedom is curtailed, he has to be brought, his body has to be brought in front of the court. What the court will do? Court will inquire into the situation under which the person was detained. And if the court finds that the arrest is legal, he'll be sent back to the custody. But if the court finds that the arrest is illegal, the person will be set free. As I told you, this is a procedural remedy. It will only ensure that the procedure with which the person is being arrested will be looked into. And it will ensure that the procedure is fair. But apart from that, if the person is arrested for a reason, later fairness of the trial is not within the jurisdiction of habeas corpus. For that, you need to approach other authorities and other authorities and other jurisdiction. So habeas corpus writ will ensure procedural fairness as far as a person's arrest is concerned. Okay. And even though now we are using it as a constitutional remedy under Article 32 and Article 226, initially in India, this particular remedy, habeas corpus, was provided by Criminal Procedure Code 1872. And they say it was in 1775 against Governor General Warren Hastings that the first habeas corpus writ was issued in India. Okay. So if you have any doubts, you need any clarifications, make use of my comment box. I've been really happy to help. The next video, we are coming up with another writ. Till then, bye.